Hello and welcome to Doyle Clayton's panel discussion all about the incoming IR35 reforms. So I'm Declan Bradley. I'm a legal director here at Doyle Clayton and a work status expert. And I've got a very expert IR35 panel for you today. We have Julia Kermode, who is the founder of IWORK, an online advisory platform for contractors. We have Ray Walker, the compliance director of WorkSum, which provides end-to-end IR35 solutions. And we have Andrew Timpson, a partner at RSM UK, the international accountancy firm. So my panel will introduce themselves in their own words in a bit more in just a minute or so. But first of all, I've got a little bit of housekeeping, if that's okay. So after the event today, you'll get a feedback form, and in a day or two, you'll get a copy of the webinar. If you could fill in the feedback form, that would be great, as it allows us to tailor content for your business needs. And you can find all our previous webinars and podcasts over on our website, doyleclayton.co.uk. And also in the console that you'll see there, you can find a handout. We're not following slides today, it's a bit more of a discussion, but no, the handout does cover much of the content that we'll discuss today. So look, anyhow, without further ado, we'll get back to today. And what I'll do now is I'll pass you over to my panel, to Julia, Ray, and Andrew, and they'll introduce themselves. Over to you, Julia.
Hi everyone, I'm Julia Kermode. I've spent the last 7 years working in the legal and tax compliance side of things in relation to freelancers and contractors, heavily involved in the development of off-payroll regulations, and spend a lot of time liaising with HMRC and other bodies in relation to it. And last year I set up IWORK, which is, as Declan says, an online resource for all types of independent workers. So that's contractors, freelancers, agency workers, and the whole lot. So I'm really pleased to be here.
Hi everyone, Ray Walker. Sorry, Declan. Hi everyone, I'm Ray Walker. I'm Compliance Director of WorkSum, which is a freelance management platform that has incorporated an IR35 determination engine within there, amongst many other recruitment needs. I've spent a 20-year career working on international payroll and management solutions for freelancers. So I have plenty of experience in not just the UK, but overseas tax products for freelancers.
And good morning, everyone. I'm Andrew Timpson, employment tax partner here at RSM, a practitioner for over 20 years. And prior to joining the profession, I worked with HMRC, or the Inland Revenue as it was back then. So you could say I'm a gamekeeper term poacher. Throughout my career, off-payroll workers has been a large part of my engagement with the clients. And recently I've been assisting with policy structures, process frameworks, status assessments, that's both with or discussing with clients and their contractors, together with stakeholder training. So a large proportion of the off-payroll preparation that should be a staple. Thank you.
Brilliant. So what we have there is a real wealth of talent, I think, in the IR35 world. So look, the audience, do get your questions flowing in. Let's test them. Let's see how good they really are. All right, but look, I think everyone listening and is probably pretty clued up on IR35 by now. But look, I don't think it hurts to set the scene a bit more and explain maybe some of the terminology we'll use, like inside IR35, outside IR35, client, fee payer, personal service company, all that kind of good stuff. So Andrew, as the technician on the panel, can I ask you to run through a quick IR35 refresher, if that's okay?
Yeah, certainly. So IR35 has been around for over 20 years now. It was established in the year 2000, and the term actually came from the press release HMRC issued at the time. The technical term is off-payroll working intermediary rules, and the intermediary for this purpose means a personal service company, which is typically a limited company. Can be partnerships, but typically it's limited companies. And if you remember back in 2000, you had the likes of the Millennium Bug that were being considered that was going to end the world. So the IT industry got a little bit of a battering because they thought they had people leaving work on a Friday, setting up a limited company overnight and coming back to the same job on a Monday, but being paid off payroll. The importance of the IR35 legislation, which was garnered and fought by the profession, is that it currently and has for the last 20 years protected companies which are called end user clients, for this purpose, but protected companies from any pay-as-you-earn and NIC exposure where they're engaging the intermediary and not the individual. This protection is being abolished. And the reason why it's being abolished is because it aims to tackle that disguised employment position, as I mentioned around the IT example earlier. It is a tax status change. It's not a legal status change, although there are many, many legal ramifications which we'll be going through throughout this presentation. The change will take effect from the 6th of April 2021, so just over a month away. Although some say we've had 20 years to prepare for this. It applies to medium and large companies. Small companies aren't impacted. Small companies, for this purpose, is as part of the Companies Act definitions, which is a turnover of less than £10.2 million, assets of less than £5.1 million on the balance sheet, and less than 50 employees. When you're looking at a small company criteria there, you need to take into group position. If you're part of a group, be it international or UK, it's your group that size that will matter, not your isolated business. An engaging company is responsible for assessing the employment status. So if you are engaging contractors, be it directly or through agencies, you will be responsible for undertaking that assessment and preparing what's called a status determination statement, which will be the declaration that you have to provide to the intermediary contractor, advising them whether they are inside IR35 or outside IR35 when you finally conclude that assessment. Sorry,
if I could just jump in. So when you do an assessment, what are you looking for? What kind of factors are you looking at?
Yeah, it's really good. So unfortunately, understanding or determining whether a contractor is an employee or self-employed, off payroll, on payroll, inside and outside IR35, there is no legislation, or the legislation is very, very limited. It's not helpful at all, and that's across the board, legal, tax, etc. So you have to consider what they call the factors of employment. There are 5 factors. Very briefly, it's substitution, control, financial risk, integration, and mutuality of obligation. These 5 factors has been determined over many, many years through the tribunals, case law, and have been mirrored by HMRC in their assessments. So the only way to get some form of accuracy to ensure that you are assessing the correct status is to utilize those factors of employment, but do so on a weighted balance. So it isn't one defining factor. The revenue will say not one defining factor will suggest or conclude a determination. That isn't strictly true, because substitution is the overriding factor that determines status. But outside of substitution, a weighted balance on those other factors needs to be considered. If you're
just as a point, Andy, sorry, I just want to jump to that. I totally agree with you on the substitution part. I suppose it's something to ask to the panel what their opinions are on substitutions, because they're so rarely used. They're so very rarely used. There are examples of any freelancers actually going into that. So whilst it's a big point, what's people's opinion on that? Should it be such a big point because freelancers are just not involved in the substitutes are not involved when freelancers are involved? So I just thought I'd open it up.
I suggested it should be a big point, because over time, it's maybe not necessarily at the beginning of an engagement that substitution comes into point, but over time things may change. They may need to bring in specialists to help them with their work. They may need to take some time off, and therefore they bring somebody else in, even if that's the agreement of the engaging company. It does make a huge difference to that status. Yeah, I understand what you say, Ray. It's not always the case. Substitution can be available, particularly where you're engaging somebody for their expertise, their experience, or sometimes it's health and safety, it's security. You can't always just swap people in and out. But certainly I feel substitution does play a huge part and needs to be taken into account.
One thing I would say on substitution is 2 points actually. If I can say one thing and then say I've got two, and that is that sometimes you see it in a contract that a freelancer or a contractor will have, but it's not necessarily a genuine right of substitution. So sometimes people do use it as a bit of a get out and hope that will then put them outside of IR35, and the HMRC and tribunals are kind of onto that. So just putting a substitution clause in will not be sufficient. The other thing that I have heard of cases where somebody is so very specialist, actually there is no substitute for what they do. Now this is kind of very, very unusual circumstance, but just to make that point as well. So they may be able to have the right of substitution, but there might not actually be any possible substitute that they could send.
And that's really important, because if you have a general project where there are a plethora of specialists out there that could undertake that role, it's more likely that a substitute actually swapping them in and out is not going to cause too much concern. But where you have that individual who's probably one of X amount in the world maybe, then the likelihood of substituting them is so remote that it has to factor in to the weighted balance when you're considering the factors. So whilst it may not, if you don't have the right substitution, the revenue will consider it a medium weighting. That's what their algorithms will do, even if you go through CEST. But if it's so specialist, you could put that medium down to low, and then the other factors take control, financial risk, etc., actually have a more higher weighting than the substitution itself. So it's a really good point, Julia, and the point on the actual contractual position. So many times, and even recently with disagreements that contractors are doing now, they're saying I have a right for substitution, therefore how can you say it's not available? That look through position, most of the tax cases that have happened over the last 10, 15 years, they've looked through the contract to consider the actual working operational day-to-day position over that, which is why mirroring the contract and the actual what's happening in practice is so important.
And just as a final point on that, I think you'll find a culture after April of there potentially being a lot more substitution. I'm seeing that with my own clients. But yeah, so Andrew, I think we sort of jumped in there, and while you were working through
let's just pick up on the fee payer point, because I think that's really important. So if you are engaging as a company, agencies or other third parties to source your contractors and not paying that contractor directly, then you will not be determined to be the fee payer. If that is the case, you need to provide that SDS to that third party, the agency, etc. If you don't do that, then them as a fee payer will not get the direction, will not understand exactly how to pay, what your determination has been, inside or outside. So if there is any exposure, it falls back to you as a company, as an end user client, for any pay-as-you-earn NIC that hasn't been collected. So it's very important you understand your supply chain position.
Okay, and there is a lot of uncertainty about how this is going to pan out, but there is a blueprint, isn't there, from the public sector? Because these rules came in a few years ago in the public sector and were rolled out. So I don't know, Ray and Julia, do you have any? Do you want to lead on explaining what happened in that sector, and maybe some reassurance from that sector you could provide, or even lessons?
Yeah, I mean, I don't mind starting off and then Ray just jump in. But in the public sector changes, it was all very, very last minute actually, because HMRC's tool that we've just mentioned, check employment status for tax tool, was only ready for clients to use probably about 4 or 5 weeks before the changes came in. So then there was this kind of massive rush to try and get organised. Whereas this time round for the private sector changes, we've known about these for a while. So firms should have some idea as to what they're doing before the changes come in April. But yeah, in the public sector changes were very last minute. We did see a lot of blanket determinations where engagers were basically saying all of their contractors were inside IR35. I have some sympathy with them doing that, actually, because it was so last minute. They didn't have the tools to necessarily take proper reasonable care. And this time around, there is a reasonable care clause in the legislation, which will require you to really essentially not be doing blanket determinations if you can. And I'll let our legal colleagues talk you through that in a bit more detail. But yeah, so there were blanket determinations. As a result of those blanket determinations, some contractors left entirely. And at that point in time, of course, they had the private sector that if they had appropriate skills, they could go and work for in the private sector. This time around, they don't necessarily have that luxury of being able to leave. I do know quite a few contractors, though, that are saying they're going to leave, perhaps they're coming up for retirement and that sort of thing. So do expect a certain amount of churn in amongst your contractor base. And I would say the main thing is to engage with the contractors, because I'm hearing quite a lot at the moment where their clients aren't really saying anything about these changes, and they're coming up in just a matter of weeks. But yeah, there was a lot of varied responses to the public sector changes, and I think we should be in a much better position this time round to make a better go of it.
I think you're right, Julia, that certainly we've had 4 years, I think it is, to ready ourselves for this, and most of the clients that I'm talking to are very much more informed, understand what's happening. And what I'm also seeing from the freelancer community as well is where their client strategy is being communicated to them, they're again much more willing to accept what the future may be. Those blanket determinations, the freelance community felt that the decisions were being made, but unjustly, whereas it may end up being that the result is the same, that they're still considered inside because that's the way the client is operating, but they feel that if it's been educated and they've been told to them in the correct way, then they're willing to perhaps accept that. I just say they don't have anywhere to go. The only place they can go if it's not private or public sector is to go to a different country. And there has been a certain part of that, but it's not necessarily been en masse that I've seen. Just some people who have decided to take it elsewhere. So
I suppose they could jump between different companies, though. If one company is doing a more bespoke approach compared to someone who's doing a very overcautious approach, so they may just go and try and get the outside engagement with someone else.
I'm certainly seeing that from having an effect on the clients. So the clients are realizing that if they don't take a fair approach, some of their competition may be, and therefore the freelancers are going to be happily working for them. And a lot of clients are fearful of that. And so it has sort of perhaps forced us down this road where a lot more people are prepared, they're making accurate determinations, and even in some cases changing their policies on how they actually work with freelancers to make the environment more conducive to an outside IR35 environment, rather than just well, everybody's inside and let's completely de-risk that part of the business. So there's it's much more fairer in this time round.
And it's taken that actual realistic position. You know, the 20-year protection that's happened has really allowed contractors to be quite familiar in their organizations, to indulge the culture, and particularly if you've got startup businesses that like to be all inclusive and a bit less corporate. So, you know, there's a mix of people. We don't know what we're doing. We don't know who's who really, because they all feel the same. So the integration is quite high. You may have some line management responsibilities, etc., because you're showing your competencies. And it's really trying to get that distance, that independent position, where you are a step back from everybody else within the organisation. And just to touch on, add to what Julia was saying in terms of what was going on in 2017. Yes, it was rushed in. It was done too quickly. I think the revenue acknowledged that, which is why there's been so much delay in some respects of the private sector. But the one thing they didn't have, which they have now, is called the disagreement process. So these blanket assessments were undertaken largely within the public sector to protect the public sector organisations, and the contractors had nowhere to go. They couldn't complain to anybody. They couldn't appeal to anybody. They could go to the revenue, but that would cause massive issues. So they've had a long drawn out process with their organisations in the public sector to try and get to a sensible position, whilst having payroll deductions taken, and then having to fight that with the revenue on the other side. So it's been a huge learning curve for the revenue in terms of how they approach this new private sector position, the legislation that they've put in place, the onus that they've done, and it does a lot of it fall back onto the employers, unfortunately, or the companies to actually perform the disagreement processes, etc. But that's done with the best intentions, because it was poorly managed in 2017.
And is there anything, sticking with yourself, Andrew, that we can tell from the public sector, well, HMRC's enforcement in the public sector arena, and anything more general, about enforcement from your own experience, and obviously being an ex-HMRC employee yourself?
Yeah, so the history of employment status with the revenue, because it's been so subjective, and you had the protections of IR35, this is across the board here, this is not just intermediaries, these are sole traders, is they've always taken a bit of a lackluster, I should say, but not a detailed review, unless it's blatant that a business is engaging off payroll workers when they should be on payroll. Their FDs, FCs, their finance teams, their HR teams are all off, for example, and there being longevity. So it's been a light touch for the last 20 years. And what happened in 2017 is they went in, they had to show that the public sector wasn't going to be given any favours. People saying money swashes around the system. But it's still got to be there, and the revenue have tightened up their belt with compliance. So it's legislative based, not horse trading, when it was when I started. So they've really have got the training, they've got the authority, and they've got the need, certainly the need now, given where we've been over the last 12 months with the government finances and so forth, to really make a robust assessments, robust investigations around this. And they have done in the public sector. They've learnt lessons. They've certainly learnt lessons in the public sector as well. We had a seminar with them in September, where they took us through the timeline, which does mirror that of the public sector. Generally, they said they'll be in within a 12 to 24 month period. They won't jump on everybody all at once. It's not to say that they won't do investigations. They certainly are going to increase their activity around investigations generally, which could lead into off payroll, just because of the strategic drift that they do when they're doing their investigations. But it's likely that they'll come in specifically for off payroll, and won't say we're coming to do a pay-as-you-earn compliance review. It'll be we're coming to look at your off payroll population. That's the power that they have, which they previously wouldn't have done.
Does that include sole traders?
It will include everybody. Yeah.
Okay.
Yeah. So the focus obviously is with the intermediaries, with the personal service companies, because of this mandatory assessment that businesses will have to do on or before the 6th of April, and continue to do through the onboarding process if intermediaries are being engaged. But sole traders are a risk. They're a big risk, because there is no protection. There has never been any protection for sole traders where you're engaged in them. So pay-as-you-earn NIC, and more often than not as well, legal rights, no doubt, Declan, will come into play a lot faster with the sole traders. So they'll be looking at that holistically, absolutely, not just the intermediaries.
And what about specific penalties? If I can stick with yourself just for one more question before moving on. So what kind of level of penalties are we looking at for non-compliance or inaccurate assessments?
So what they have said, and we do believe them on this, they've said that penalties will be a light touch approach, where the business has been committed to compliance. They've got a framework for their compliance. They've got policies in place, as Ray said earlier on, around changing of policies and considering that. It's a big must to have a policy, and a policy with approvals. So it's not just sitting on the shelf, it's actually enacted. A process for your assessments, responsibilities for those assessments, and also the competent and robust status determination statements. And big thing of all is communication with the contractors, with your agencies if you're working with agencies, supply chain look-throughs, making sure that they're doing exactly what you're asking them to do. All of that will demonstrate you've got a robust process. That should be a light touch. Even if the revenue don't agree with some of your determinations, it should provide for a light touch.
Okay, and another thing about HMRC enforcement is, from what I've seen and read, is that they're saying, look, we won't take the status determination statements or information from April and chase you down, contractors, for previous years. But I suppose, Julia, this is a question for yourself. Do contractors believe them, or are they very concerned about their current engagements, which might be inside, and then they're going to get chased down? And is that making them shop around maybe for different outside engagement?
There's a lot of concern about being potentially staying in the same assignment, but going from, you know, being outside IR35 when they were doing the determination themselves to then being declared inside by their client. There's a lot of concern about that then triggering a potential investigation. Now, we know HMRC are saying that they won't necessarily do that, but I have a lot of sympathy with contractors who are concerned about that possibility. So that may be driving some of their concerns if they're talking to clients about, you know, appealing the status determination that they've got. There may be a genuine concern there, and it might be that those contractors might look to change the role they're doing entirely, perhaps, if that's possible, or even come out of the business for a period of time and then go back at a later date to kind of really. There's no guarantee, but to kind of make it less likely that HMRC would look back over the years. So yeah, it is a concern, and I think if clients are alive to that, I think it's actually really helpful.
And I think you mentioned, Ray, a bit earlier that clients may be giving themselves a commercial risk through loss of talent if they just adopt a sort of blanket IR35 approach.
Yeah, without a doubt. I'm finding that they are having to be more considerate towards their freelancers, or possibly what they're taking into account is what the impacts of IR35 reforms might be having on their freelancer base. Whereas in previous, you know, what happened in the public sector, they didn't necessarily do that as such. And even just a year's delay has allowed them to sort of look at things perhaps differently. Because we got so close to the start time this time last year, they were much more aware, and that delay they've now been able to say, okay, what can we do to actually consider how we engage with our freelancers, what it all means to them. So yeah, there's been a lot more awareness on that, I would say.
Yeah. And on that, and how do they engage with the contractors? How do they do this process? And what is an IR35 process? So in general, now I've sort of seen a sort of 5-step plan as such being carried out. I know the first step is working out if the IR35 reforms are even relevant to your business or not. Are you big enough? Are you wholly overseas? Do you have IR35 contractors? And then the second step, if it applies, is getting your investigation team in place, senior led, so they can have difficult conversations in the business. They use tools like IR35 online platforms and spreadsheets to sort of find and record the relevant information, make provisional assessments about their contractor base. And then in the third step, the IR35 team would sort of consider those provisional assessments with senior management to decide if there's any alternatives. If everyone seems to be inside, do they want to outsource to a service provider instead of using contractors? Will they just keep them inside, etc.? Then the fourth step is making changes, if there are going to be any changes made. And then the fifth step, when it comes, satisfying your IR35 obligations. So it seems like a pretty foolproof process. But obviously, if there's anyone listening today and there's only a month to go, then they may be concerned about what they can get done in that time. So I suppose sticking with yourself, Ray, and because you come from the IR35 solution side, is there any recommendations that you can give to follow a sort of an efficient process, focusing on the sort of key issues within the next few weeks for your current batch of contractors?
Yeah, I mean, all what you said there, totally agree. That process is exactly what needs to be done. But having a robust system around that is really what's required to make sure that nothing falls through the gaps, because that's the fear of you might miss freelancers. And firstly, that first part, identifying the freelancers, and that's what we take to our clients really, is giving them that platform and that product to be able to organise their freelancer base, understand what they've actually got there. We've got a number of people who are in the creative industries, and that means that they actually work with a lot more sole traders than limited companies. And even their misunderstanding on what that means to their business, just by identifying those sole traders, has actually helped them to be able to identify what risks that might mean to the business, whether that's IR35 relevant or not. It also allows them to identify the key people in the business. Who's the ones that, if you was to lose tomorrow, that might affect your business in a big way. And you say, well, actually, I'm going to lose a big client. I can't afford to lose that freelancer. Therefore, let me pay them as much as I need to if they're going to be inside, because I'm going to lose more money otherwise. But those systems allow that. And then when it comes down to just the determination part, as Julia was saying earlier, you've got that reasonable care aspect. So having a system around it and having the evidence that you can then come back to at a later date can then show you that you actually took reasonable care in reaching that determination. And whilst the determination could still be debated, that reasonable care aspect has been taken out of it, which is a huge aspect, and one that HMRC rightly can then take back and say, well, you are still the fee payer, Mr. Client, because you haven't actually passed on your responsibilities correctly. You didn't do it with reasonable care, be it a blanket approach, be it a totally naive approach and just imagining everybody's outside because that's how we play, whatever it may be. But those systems definitely control and stop people from wandering outside the boundaries. It also means you can actually, your staff, you can manage in a correct way as well, so you don't have anybody paying a bit fast and loose with a freelancer because I need them on the assignment and I don't really care about the impact of what it means to the business. People in control, and on that, as you say, that senior IR35 team, they can see and understand that and can be assured that actually their staff members are working to in line with the policies that they've created.
Can I just chip in, if that's okay, on that exact point, Ray? Because one of the things I've seen is exactly what you've described, where someone else is kind of overruling the IR35 determinations that the business has made. So so that does happen, and that did happen in the public sector. And we saw. So I wanted to say, be very, very clear about who the decision makers are, and make sure that that's clearly kind of outlined and cascaded throughout your organisation. But the other thing we are starting to see is a suggestion whereby if somebody is determined inside IR35 for tax purposes, then their rate is not being necessarily changed to take account of the additional overheads of that. There is starting to be some cases where those contractors are being told, well, just bill for more hours then, and to kind of up their pay. And we're laughing, it's ridiculous, but actually that's massively, well, not only is that ridiculous, but it's also kind of fraudulent potentially on that contractor's part. And I don't know if you've seen any of that happening with any clients. Hopefully not. None of the panel members.
Shouldn't be. There's a thing called the Fraud Act 2006, I think. You'll see it often in recruitment agreements between the employment business and the client, or even the employment business and the contractor. Make sure you do not falsify your timesheets, because that can be an act of fraud under this particular piece of legislation. So they definitely should not be doing that. No. And what companies will be thinking about is we talked about systems, but what does that mean? And companies these days run on technology. So I suppose, again, this is for you, Ray. What does technology look like in the IR35 space to help organize and help people do investigations and satisfy?
There's many different types available. There's a number of different suppliers out there who are doing determinations, and because it's on a platform, it then means it's a robust system. It then means that can be checked by external companies such as the insurance providers, and they're able to provide an insurance policy behind the outside determinations. So if they happen to be challenged by HMRC at a later date, the insurance company can come in and actually pick up that fight. So that's probably one of the biggest parts about technology, because it's repetitive. There are like what we've actually done is we've adopted our own determination into the freelance management tool, which means that we can manage the entire job requirement from the actual requirement stage through to the hiring stage, through to the determination, and then the actual time management. And as you say, Julia, with regards to people who may be trying to increase their time, that there can be controlled within a management area so that people will authorize or throw back the timesheet, whichever it may be. So that, you know, technology really, I think, is the way to do it, because it's also scale. What you can do is with a technology platform, whether it be just purely for your determinations or taking on, you know, more things on top of that, is you can ramp that up to you know, hundreds of freelancers, thousands of freelancers if you happen to be in that boat. And then also that doesn't necessarily have to be the same for an ongoing. You might have a period where you've got, you know, lots of freelancers in the summer, for instance, and then it dips down later on in the year. So you can then use that system to carry on that weight. And then when the business drops down, you then scale back, so you haven't got that cost running through your business. Whereas if you were using, you know, physical people, you've obviously got to worry about when you hire them, when you train them, and obviously having to say goodbye to them when you're the surge in the business has died down. So yeah, technology to me is certainly the better way of handling it because of the control aspects you can put on.
Yeah, but no, there are obviously people involved in the chain as well, and I think you made a good point earlier, Julia. You were saying that some contractors haven't even been involved in any discussions. They've no one's had an IR35 discussion with them, which is, you know, seems to me a bit crazy, because they will be such sources of information, as well as, you know, a big part of the equation when deciding what happens next, terminate engagements, you know, reorganize them. So, you know, do you think contractors as a whole, in general, Julia, are sort of willing to provide honest and accurate information, and they have pragmatic discussions where they might have to change some things up?
I think so. It's certainly in their interest to engage with any process that their clients are putting in place. And some of the factors that may make someone less likely to look like an employee will include having multiple clients. And of course, it's only that individual contractor that will know whether they've got multiple clients. So those sorts of things, you would hope that there would be a conversation around that. Or if the client is making an assumption, then the contractor has an opportunity to say, actually, no, I do have these other clients that I work with, and they're able to kind of prove that, and all of that side of things. So there's quite a lot around the whole determination process. And I do think that in an ideal world, if you've got time to engage the contractors in that's really helpful, because also sometimes the people making the determinations might not know actually how things happen in practice. So they might be slightly removed from the work actually being done. So I would encourage people, if they can, to involve their contractors in the process as early as possible.
Excellent. And
just to jump in there, just in doing so, because I've worked where we've spoken with the contractor and the client to get parity in terms of the answers to the questions that we're asking, and making sure that both sides are there. It stops, or at least reduces, the risk of disagreement, because, or at least going into a formal disagreement process where you've got that dialogue open, you're taking both sides of the equation into account, and you're coming up with a sensible determination based upon consistency, because Ray, what I was hearing through your technology thing is consistent approach, and you'll need that consistent approach when it comes to HMRC investigation, because if it's all over the place, you've got biases here, you've got differences here, you've got different people doing, the revenue will just tear it apart from a controls perspective. So consistency, but certainly getting that engagement with the contractor into your assessment status, it will help on the longer term.
Excellent. So if I can just maybe circle back to a point I was making around, I think it was is it the third step in my 5-step plan, where you consider alternatives? If you're getting lots of inside IR35 contractors and you don't want that, now what are the alternatives? So one that comes up, and one that is a viable alternative for sure, is a contracted out service. So that's, instead of say using 10 IT contractors to perform a project for you internally, you just outsource that project, if it's IT, to the likes of Infosys. In that case, and as HMRC call that contracted out service, in that case, the contracted out service provider, they become the client for IR35, not the end user. So you as end users, that is a good way, if you can genuinely arrange that you can then sit outside the IR35 compliance process. Sounds simple, but there is so much confusion around this, and particularly what I've seen in the recruitment sector. And so I was thinking, Ray, maybe you could jump in and tell us a bit about the confusion in the recruitment sector around this. And I think they often call it statement of work approach. And what are the risks? Because maybe we're, I suppose, talking to end user hirers here. So what are the risks for the end user hirer there? And is there anything they should be looking for when they're engaging with a genuine outsourced service provider?
I think that's one of the parts, is it genuine? And I come across many clients who have heard about statement of work. They see it as possibly being a magic wand, that IR35 doesn't exist if a statement of work is used. I've heard that term mentioned many a time. And as we know, statement of IR35 does exist. It's just the reforms won't necessarily apply to them. So the new client has to do the determination. But there's probably more misunderstanding in that area than any other area. And what I'll always say to our clients is, you need to truly understand what a statement of work is. You need to be taking advice on that to make sure that the correct contractual terms are being used, the correct engagement structures being used, that it isn't, a supply of labour dressed up in sheep's clothing. And therefore, because if it is, it's quite simple that HMRC will come in and say, well, it is a supply of labour. IR35 reforms do exist. You didn't take those. You found reasonable care, and all of the knock-on effects that's going to have. So for me, what I see is probably the greatest misunderstanding within the industry, and people need to tread carefully around it and make sure they've got the correct advice before accepting a statement of work.
Yeah, and like it's quite easy just to go online onto Google if you're listening and just type in employment status manual, HMRC, contractor out service, and you'll really see there what HMRC will be looking for in a contractor out service. And it's not someone who's a recruitment company one day and then the next day they're an IT company or a catering company and basically providing the same service. And that's not going to wash. So just be very careful of that and make sure you got the courts will look behind it, but a good starting point is make sure you got the right type of outsourcing agreement in place. And I always think a good thing to think about is you as a business, if you're big enough for this to happen, you're going to be outsourcing services already, most likely. Are you following the same steps with these statements of work as you are for your other outsourcers? If not, it's probably not outsourcing. It's probably not a contracted out service. So just keep that in mind. I think were you going to jump in with something there, Andrew?
It's about the DNA of the experience that you need running through that business. So if you're just they're finding a labour supply for you, then it certainly isn't running through their business. You've got to engage a business with the experience. Looking at an RSM or a Doyle Clayton. You're not going to Doyle Clayton to get an accountant. You're going for legal advice. So. And the same with RSM, the other way around. If we are supplying a labour to you, then that is not a contracted out service. It's a labour supply. So just it's just the revenue will be steadfast on it. They'll be wanting to understand what the contractual arrangements are and how they got comfortable within their processes that it was a fully contracted out service.
And my question to follow up was basically on HMRC. If they look at an arrangement and think, look, the client and the recruitment company here have deliberately just sort of papered this as contracted out service so that the assessment responsibility passed down to the recruitment company. Lo and behold, the recruitment company is too small for the reforms to bite, so it passes back down to the contractor. Contractors clearly going to put themselves as outside IR35. Are we getting into higher levels of penalties there for
not just high level of penalties. The penalties will certainly go up. They talk about 100% penalties. It's more likely if it's deliberate, it's 70% of the liability. But you're actually looking at tax evasion.
Okay.
Or at least facilitation. Easier for me to say that, wasn't it? Facilitation of tax evasion, which is caught by the corporate criminal offence rules, which came into place in 2017 September. And they are unlimited liability. So and that does not impact size of business. It impacts all sizes of business. It impacts globally as well as UK. So it's a catch-all situation. So if businesses are looking to try and get around by different arrangements and so forth, then the CCO will be very, very detrimental to them.
And is that just where they've sort of arranged it so they don't have the assessment responsibility, as opposed to, because if the contractor put themselves as inside, then I suppose will HMRC care then? Are they only going to care when they say they're outside? And will it matter if the client and the recruitment company have then tried to pressure the IR35 contractor to say it's outside? Or no, is
you're
it
talking about fraud.
basically?
You're talking about fraud. You're talking about, so for example, a client goes to a third party who engages contractors with offshore intermediaries. You know, that's the classic one where the revenue would be suggesting it's fraudulent, and therefore would be harder on them. Or that pressure, like you say, the pressure to go off payroll, although it's down to the individual integrity whether that happens. But it's anything to do with trying to suggest as an arrangement which we can get around. Not it's legitimate. It's a contracted out service. We needed audit advice, so we went to an auditor, and that auditor happened to just need some resource, and they brought in a contractor to help with the project. That's different. But if it's a deliberate, you set that up, we'll set this up, we'll do this, we'll do that, then you're looking at facilitation of tax evasion, which brings in those harsher penalties. Okay,
so basically be quite prudent when approaching these statements of work. But in reality, what they're called is contracted out services. Now that is the terminology that HMRC is using. So do look at it and see if it's a proper outsourcing and not just provision of labour badged up. Okay, and so Julia, on the contractor side, are you seeing any contractors who are worried about this? Are you seeing any contractors maybe coming to you and saying, look, I'm being asked to do this, I think it's wrong, what do I do? No, is that happening or not?
Yeah, it is a little bit. Thankfully, I'm not aware of it being massively widespread, but obviously the contractors themselves need to be aware of the potential for them to be committing fraud and the potential impact on them and their business. So, you know, although contractors may feel, you know, aggrieved if they are determined inside IR35, I'm sensing that they're reluctant to be out there defrauding everybody by spurious means. But yeah, I imagine it is going on, but I'm not getting a huge number of inquiries about that.
Okay, I suppose, you know, if a contractor came to me, I think my first protocol would, or my first piece of guidance would be have a conversation, you know, with the recruitment company, with the client, just to see what their intention is. And to see if they understand the risks, because then the conversation might flow in a more appropriate way from that.
Yes, that's true. And I think certainly in some sectors where there are like contractor rich sectors, if you like, so there's a lot of IT contractors out there working for lots of different end clients, they might be more likely to be mobile and move if they're not comfortable, whereas, you know, the contractors that are a bit more niche are a bit more of a concern, and I suppose a bit more at risk of kind of this sort of shenanigans, for want of a better word. So yeah, they should most definitely have that conversation.
That's a great word.
That's a great word.
One of my favorite words. So look, I think that kind of brings us near the end of the sort of main discussion points. I've had a couple of questions here from the audience. We'll look at those in a minute, but no, do feel free, audience, to start sending them in, and we'll have 10 minutes now to discuss them. But if I can very quickly, and I've made some notes very quickly, just sum up what we've discussed today. In five, no, I love my 5-point processes, but 5 key points I think to take from today. So first is that, you know, the clients need to understand, if you're big enough and you use contractors or personal service companies, that responsibility for doing the assessment will pass to you. Second, HMRC will take a light touch approach, it seems, in the first 12 months anyway, if you get the assessment wrong. But third point, if you don't do anything to try and satisfy your obligations or do a proper investigation, then you'll probably not get the light touch. The fourth point is, you know, doing the proper audit then, you know, to lessen that risk, and just make sure you got the right team in place with the right tools and who can have difficult conversations internally as needed. And then to end on a nice negative note for the 5th point is that, you know, beware of IR35 get-outs, like statements of work which seem too good to be true or too easy. Now, if it's an outsourcing, it's not probably going to be easy. You're going to have a big agreement in place talking about lovely employment legislation like CHIPI, if you've ever come across that, etc., etc. So yeah, so that's my 5 key summing up points. Does that seem like a fair summing up to the panel?
Yeah, that sounds good.
Brilliant. Right. So what we'll do now is we're going to really test your knowledge with some quick fire IR35 questions. So the first question we have from the audience today is just to maybe repeat very quickly the 5 factors of employment. And I would say they should be in, I'm sure they're in Andrew's slides anyway, that's on the handout. But very quickly, the 5 key factors, sorry, of employment.
Yeah, so substitution is the first factor, and as we all have sort of agreed, the overriding factor. Control is the next factor, and actually these are in order on the revenue assess tool. Financial risk is the next one. Integration into the workforce, and then finally mutuality of obligation. And just a point on mutuality of obligation, it isn't included within the assess tool to any high degree. There is one question that is devoted to it, and only very discreetly. The tribunals though do consider it a lot higher than HMRC. So don't look at mutuality of obligation with a lip service position. You need to consider it quite fairly within the round. And
look, we get these questions all the time in any other webinar I've done, but it's all around international arrangements and when they come into play, or when IR35 or IR35 reforms come into play, whenever there is an international element. So unfortunately, Andrew, I'm going to pick on you again. Sorry about that. So I'll give you three quick scenarios, if that's okay, yep. Or 3 quick questions on this that have come up in the past and are coming up again today. So the first one, which should be simple. So you have a contractor who's not based in the UK as an individual, who does not have a UK company, but is just performing their services from afar for a UK business who will say is big enough to be caught by IR35 reforms. Does IR35 apply? Does the IR35 reforms apply?
Yeah, so in principle, if there is no UK tax residency for the individual, then the IR35 position shouldn't apply.
Okay, seems simple.
Very difficult for businesses to with certainty say that will be the case, particularly if they are a UK national with family in the UK and they are just having to provide the services in another country. So just be wary of that. But yes, so in that first instance, IR35 rules shouldn't apply.
Okay, and then obviously with COVID, what's probably been happening is you have people who were based in the UK before, being a contractor, got their contractor company here, but maybe they're from Spain, maybe from Republic of Ireland, wherever it might be. COVID hits, they go back home to be closer to their family and think, I'm going to stay here. And then they are now performing their services as an individual based in the foreign company for the UK company, but they're a personal service company still in the UK with company's house and probably paying corporation tax, etc. And that's what they use to contract. So IR35, not IR35.
This is where the grey area comes, because if they've previously been living and working in the UK and now they've decided just because of the pandemic, it may be prolonged, but because of the pandemic, they're going to go back overseas and be with their family. The company have got a decision to make, because technically, if they're going to remain outside of the UK as an individual and not be subject to UK taxes, IR35 shouldn't apply. However, there's a risk, and the risk is that they do decide to come back into the UK. And the moment that they do that, they may become UK taxable, and therefore IR35 assessment should apply. So in that instance, I would suggest a prudent approach would be to do the assessment. If they are maintained outside and they don't come back to the UK, there's a gross position because there's no tax here. But if they do have a travel pattern into the UK, you've got the assessment, and then you can make the right determination, be it payroll or not.
Okay. So we've probably said the word risk about 1,000 times today. And clients are always looking to sort of de-risk it, and they're always looking to lower that risk. So I suppose this is a question for yourself, Ryan. You did touch on this already. A go-to with de-risking is often insurance cover, and I do get asked that for whatever it might be, GDPR, IR35. is there any insurance for this? So I suppose that's a question for yourself, Ray, and maybe don't promote any particular products or my compliance officer will chase me down. So yeah, over to yourself.
Yeah, no, there are insurance products in the market for companies who are going to go with an outside IR35 determination. But as with any insurance, those underwriters are going to want to be able to see what they're underwriting. They're going to want to be able to quantify that. So, and that comes down to how you're making the determination, what knowledge, what skills you've got behind that, how you're, what processes you've got behind that as well. The ongoing maintenance of that assignment as well, whether that's going to drift, whether there's a chance of drifting, and what they'll underwrite for that. So absolutely, there's insurance products out there, but as with all insurances, it's got to be quantifiable, and it's got to also stack up if there's any scrutiny behind it.
Okay, and so just quickly staying with risk, I know we're getting near the hour. So obviously with companies trying to de-risk themselves and push it back down to the contractor with insight results, or maybe just not using contractors anymore and the outsourcing like we talked about. So Julia, are you seeing any kind of sea change in the contractor world? Are you seeing lots of contractors giving up their personal service companies, going back into the employment fold? If I can be dramatic, is this the end of contractors as we know it?
I would say it's not the end of contracting as we know it. There's been a number of different changes over the years that have affected this sector, because the government kind of views it as a risk sector, if you like, in terms of tax and that sort of thing. But yeah, I am seeing contractors who are ready and willing and considering retirement, for example, as an option. But that's partly because of their kind of stage of their lifestyle, etc. So this might just be a catalyst for that in some circumstances. But I'm not seeing a wholesale change by any stretch of the imagination. And you know, those clients that are engaging their contractors early on, and I know I've said it already on this, that they're the ones that are going to retain them and retain that workforce that they need.
Okay, and then very quickly, Ray, are contractors with PSCs, are they now hot potatoes in the recruitment world? Do clients not want to touch them? Recruitment companies not want to touch them? What's happening?
No, not at all. No, okay. From what I'm seeing, the clients just want to try and identify how they can work with those if they're through PSCs. But what I've also seen is, and it goes back a bit on what Andy was saying about sort of that detachment that you need to have to those type of freelancers now. What I've also seen is the flip side of that, of those that are going to be considered inside. The clients are now going, well, we can actually be a bit more warmer, a bit more cuddly with them because they're paying employment taxes now. We don't have to be so detached. We can look at sort of how we can give them some kind of wrap them up into our benefits, take them to the Christmas party, for instance. So it's a bit colder, a bit harsher, the other side of the fence, but a bit warmer the closer you are to the client.
Okay, now as an employment lawyer, I would say still treat them with a certain level of detachment in case they bring the employment rights claims. But I mean, yeah, no, I get that, and I do know some clients who are saying, right, well, now they're inside, we'll take some more control. Thank you very much, Axton. We'll have a bit more control over substitution, more control over what they're doing. So yeah, no, I do agree that clients are thinking about that as well, and the benefits of an inside relationship. So I think that brings us to the end. So that was really great, I think. So thank you to the panel, and also thank you to the audience for tuning in. I hope you found it useful. And as I said, there'll be a feedback form after the event, as well as some information with our contact details. So if you do have any burning questions which come up after the event, feel free to get in touch with any of us, and we'll definitely be willing to help. Okay, so I think that's it. So thank you very much for tuning in.
Thank you, guys.
Thanks everyone.